quashed by the Supreme Court.
He was meant to be out.
He was meant to be out one way or the other. But of course, you see the Supreme Court now, that is one of the areas which many of us didn't pay close attention to, but which became a source of problems and has resulted into illegal detentions of many people, despite that decision. The Supreme Court made an order saying all the files before the court-martial should be transferred to civilian courts.
How problematic was that?
If there is a criminal file and then the court says, the court which is trying this case has no powers to try it, this case should now go to the civilian court. Technically, the court is saying, no, the case is still there, but only that let it go to the competent court for trial. So what happens to the person who is on remand? Can the person be released? No. Which would be the right court to release this person? It would likely be the civilian court. So what should have happened, in my view, the legal teams for all these individuals who are beneficiaries of the decision should have moved the civilian courts with a floodgate of applications for release and bail applications. For some time, many were not filing them, but eventually, some saw the need and filed them. I know, for example, with the council...
If I could interrupt you here. In the aftermath of the Supreme Court decision, there were a lot of gymnastics, a lot of interpretations across board. Did the Supreme Court decision come off as ambiguous?
I don't think the decision was ambiguous. The decision simply gave a problematic order. The order about transferring cases from the court-martial to the civilian courts was, in my view, ill-advised. This is the first problem. You see that the DPP, the Director of Public Prosecutions, does not institute criminal charges in the court-martial. The charge sheets, which are in the court-martial, are not signed by anybody associated with the office of the DPP. Criminal charges against civilians in civilian courts are launched under the authority of the Director of Public Prosecutions. At the time, that was Her Lordship, Jane Frances Abodo, who was in the office of DPP. So, the first problem was you cannot transfer a criminal case from the court-martial to a civilian court because the charge sheet, which is on that file in the court-martial, was signed by the army, by the prosecution's team of the army. And that prosecution's team of the army is not under authority of the DPP.
Right.
So when you move that file to a civilian court, still it is a non-charge because there is nobody to even supervise that criminal charge. The DPP has nothing to do with it. And so what that means is that the Supreme Court judges made an error in making that order. They simply should have ordered that the DPP is permitted to institute new charges against the people who are in the court-martial under her discretion. And that if no charges are brought, they must all be released. That would have been clearer. Also have no business in the civilian courts. The DPP has no business in the court-martial. So you have this bunch of files that are transferred and there's nobody responsible for them on the side of the prosecution.
I remember after the court-martial, some lawyers, some legal minds were looking at it as a relief for Colonel Dr. Kizza Besigye, and that his freedom would be regained in just a few weeks. But ever since, there's been a lot of ping-pong. The case has been mired into now challenging the jurisdiction, calling for transfer of files, and the judges. Do you want to mean that there is a lot of exhaustion of the entire legal chain?
Yeah, and I think this is what happened. So, Dr. Besigye was supposed to benefit from it in two ways. Number one, for him, he did file an application for what we call habeas corpus. In other words, when a person is illegally detained, you can apply to the High Court to order the person to be unconditionally released. Dr. Besigye filed that application. It went before Justice Dr. Douglas Singiza, who is now the chairperson of the Judicial Service Commission. He declined to grant it and instead insisted that Dr. Besigye could only apply for bail from the criminal division of the High Court. So, and that's the time when Dr. Besigye, as you remember, was on a hunger strike. We all saw those images. He was in a very bad shape, and many of us were rightly concerned and were blaming the state for that situation. So a few days later, after Dr. Besigye's application before Justice Singiza, Dr. Besigye was hurriedly charged now in a civilian court with the offense of treason.
On a new file?
On a new file in a civilian court. So from that point, for him, the issue to do with the army and the court martial came to an end. He was now in a civilian court. But remember that it was still the same person who had been on remand by the court martial, and his remand continued. He was never given any freedom. Okay? So, from the date he was arrested, he was in detention. The Kabazuguruka judgment is delivered. He applies for habeas corpus. He's not released. And then eventually he's charged afresh. When you are being charged for the first time, where do you come from? Do you come from prison, or you come from home, or you come from a police station? What usually happens is, if you are going to face a charge for the first time, either you have been arrested from a police station and you are presented before a magistrate's court, or you are issued with a criminal summons and you come from your home and you go and report to the court to hear your charge. But Dr. Besigye was coming from prison. He was produced by prison authorities.
So do you want to suggest that even the prison authorities were illegally holding Besigye?
In a sense, they were illegally holding him, because they were holding him when there was no charge at that moment. He had no valid charge. But the problem came from the habeas corpus application, which was supposed to lead to his release. The idea
was it poorly filed?
No, it was not even poorly filed. Justice Singiza should have ordered his release. And then, if the DPP wanted to charge him afresh, so be it. But he should have been released on that very day, because the day he was produced on a habeas corpus application, he had no pending charge. And so he's produced before the Chief Magistrate's Court in Akawa. He's charged with treason. And indeed, I think even he even calls off his hunger strike, because that is all he had also wanted. By then, there was this assumption that the civilian courts, the judiciary, is now going to follow the law, and we can all sit back and rest and leave the processes to play out. I think that was the assumption. So he files his first bail application. I think that was a few months later, before the Honorable Lady Judge Rosette Comfort Kania. And shockingly, she dismisses the application for bail. She agrees that he has presented.
From Singiza?
So from
now
Justice Singiza,
it is Kania.
Yes, Justice Rosette Kania, she dismisses his application. And when you read the ruling, she relies on the legal position of bail pending appeal. When a prisoner has been convicted and appeals to the Court of Appeal, or appeals to the Supreme Court, and then applies for bail pending appeal, the legal position there is very different from a prisoner who is pending trial. When a person is pending trial,
Justice Kania depended on
legal principles for bail pending appeal.
Upon conviction?
Yes, upon conviction.
Okay.
And yet here you have a person who has not yet been tried. And our Constitution, Article 28, Clause 3, provides for the right to be placed, been convicted. First of all, they have a presumption of innocence. And therefore, the threshold for granting bail at that level is way easier. It is the shock of many of us in legal circles. The High Court judge uses principles for bail pending appeal to deny Dr. Besigye's application. At that point, I knew there was a big problem, Because the signal now seemed to be that the law is not going to matter where Dr. Besigye is concerned. There seems to be, it seemed to me that the judge was simply had a decision. The decision was no releasing Dr. Besigye on bail. And therefore, then the court had to work backwards to justify that decision. That is what it looked like. Because surely, every High Court judge knows principles for bail pending appeal are completely different from bail pending trial. That is one. So his bail application is dismissed. He stays in prison. And then a few months later, he now applies for bail under Article 23, Clause 6A. Under our Constitution, if an accused person is on remand for 120 days before trial, they are entitled to be released on bail. That's the law. Someone is on remand, 120 days, what is 120 days, 180 days? We can cross-check that. And has not been tried. The Constitution says that person is entitled to be released on bail. Why? Because at that point, I think that the members of the Constituent Assembly who drafted and passed our Constitution were mindful of the fact that the state may occasionally arrest and detain people and charge them with no serious interest in trying them, and then use pre-trial detention as a form of punishment. Pre-trial detention, detaining a person in prison before they have been tried, is not intended to be a form of punishment. Generally, pre-trial detention is supposed to be for people whom the court worries that if they are released pending trial, they are going to escape. They are going to run away.
Right.
But once the court has some reasonable degree of understanding that this individual, if released, cannot run away, that person has no business being detained before trial. Prison is intended for people who have been convicted, not people who are pending trial. The only people who should be in detention pending trial are people who are likely to run away, people who are very violent and maybe who are charged with serious offenses, but also who have demonstrated that they are, and the court must have evidence that they are interfering with the witnesses. In other words, the court is not supposed to say, the way we see Kagwanjara, he's influential. We can't give him bail because he will interfere with the witnesses. No. The DPP must bring evidence before a judge to oppose bail and say, we have evidence that Kagwanjara has been trying to contact our witnesses. Please don't give him bail, because if you do, he's going to tamper with our witnesses and keep harassing them.
As we delve more into the intricacies of Besigye's trial, Besigye and Obed Lutale, at the onset, the state came out and they were all over telling the world how there was sufficient evidence pinning him on the case for which he's being charged. Has the case ever changed from arms and everything that the court-martial was arguing initially?
Oh yes, there were some changes on the charge sheet. Illegal possession of firearms was removed.